Paris, after a long day of closing arguments, the verdict of the Derek Chauvin trial is now in the hands of 12 jurors. The former Minneapolis police officer faces 3 charges for the death of George Floyd: second-degree unintentional murder, third-degree murder, and second-degree manslaughter. Joining us to explain these charges and to dive into closing arguments are Dan Herbert, attorney with Herbert Law Firm. He represented former Chicago police officer Jason Van Dyke when he was on trial for the death of Laquan McDonald. And James Montgomery, attorney with James D. Montgomery and Associates. Gentlemen, thank you for joining us. Dan, let's start with you, please. What are the differences? What's the difference in these 3 charges?
Well, the difference in the charges is you can really focus on the intent aspect. With the second-degree murder, there is an intent requirement, and the intent is that Mr. Chauvin committed a felony while he was doing these actions. And of course, that was a big part of the trial and the evidence that went in. With regard to the third-degree murder, it's essentially that he committed an imminently dangerous act that wasn't authorized. And then the manslaughter is obviously a lower count than all 3 of those.
And because Derek Chauvin is a police officer, is one of those charges more difficult to prove than the others?
I would think that definitely the second degree is more difficult to prove, and I think the prosecutors recognize that by making sure that there was a third degree charge. The state did a very nice job of saying that these actions of being prone, having them prone and being on top of them were not authorized. So if they're not authorized, then the jury can conclude that there was an intent not to detain, but to punish.
James Montgomery, how did the prosecution make their closing arguments?
Well, the part that I saw indicated to me that he was extremely delicate with the jury. He was not he behaved as if he was speaking to people that didn't want to hear what he had to say. And I thought that was a wise move, because it's very difficult with a police client to get a jury to find them guilty. And I thought the way he went from the point of view of from the heart to what you saw on the black and white, and basically it was not a roughshod running prosecutor. He was a gentle gentleman who was trying to just share the facts with the jury in a way that was not challenging to what some of them may have a belief, and that is that a policeman can do no wrong.
And we're going to come back to that closing argument in a second. But Dan, the defense has tried to sway the jury by debating the cause of death. What were they saying could have happened outside of Chauvin kneeling on Floyd's neck?
That was definitely their strongest argument. It was a use of force, and then it was a causation. Mr. Floyd had an enlarged heart, and then he ingested drugs. And then he had the evidence of an elevated blood pressure, certainly at that previous incident. So that's clearly what they're saying, is that the drugs and the elevated heart rate and the enlarged heart, those were substantial causal factors. I don't know if it will be effective with the jury, but that's essentially what they're saying.
Now, here's a clip from the prosecution today during closing arguments.
This case is exactly what you thought when you saw it first, when you saw that video. It is exactly that. You can believe your eyes. It's exactly what you believed. It's exactly what you saw with your eyes. It's exactly what you knew. It's what you felt in your gut. It's what you now know in your heart.
James, is this a compelling argument for the prosecution?
Absolutely. I think that is the most effective way to speak with this jury under these circumstances. Yes.
Why so? Why was this the most effective way?
Because it is not challenging their beliefs. It is challenging what you see, what you feel in your gut, and what you feel in your heart after looking at what happened on the video. It's not, typically what you find prosecutors doing is being self-righteous and law and order, etc., and tough. This gentleman handled it in a way that was palatable, in my opinion, to this jury whether they will accept his argument or not.
Now, the defense argued that the prosecution wasn't showing a complete picture. Here's a look.
Throughout the course of this trial, you've seen us do this, right? Little snippets. A second here, a second there, a screenshot here, a screenshot there. You need to review the entirety of the evidence in this case during the course of your deliberations as well. And I can tell you that some of the videos that we've seen, they're much longer than what was presented in court.
Dan Herbert, will the jury believe that?
It's an excellent question. I don't think they will, but clearly, and I agree with my colleague on this, that if the prosecutors are trying to make this as simple as possible, there was a visceral reaction when people saw that tape, and the prosecutors want the jurors to just think about that visceral reaction, whereas the defense wants to really show all the elements and highlight this burden of proof and presumption of innocence. So it's definitely two different contrasting views here. And, you know, I don't know. Here, I couldn't see the jury. I saw a lot of how the evidence went in, but as James will agree with me on, until you see those jurors and what points they're taking notes on and what points are resonating with them, it's really hard to predict what they're thinking.
James Montgomery, how do you think the makeup of the jury might impact the outcome of this case?
Well, I think it's a majority Caucasian jury, and therefore it'll affect the outcome quite a bit, because all you need is one or two of them to decide that they're not going to find him guilty of anything, and you'll have a hung jury. And unfortunately, in these kinds of cases, that happens more often than not. Jurors believe, white jurors believe, that the police officer is your friend, and indeed he is, and he's been their friend. Black folks, on the other hand, are afraid of the police and have good reason.
And before I let the two of you go, Dan Herbert, you know, there have been many comparisons between this case and some others, and of course that of your former client, Jason Van Dyke, in the death of Laquan McDonald. How do you see it?
You know, I was very close to the case with my client, obviously. I see them as polar opposites and very different from the two elements here. With our case, the cause of death was not at issue. In our case, I thought that there was a much more robust debate that could have been had with respect to the appropriateness of the use of force, whereas with Chauvin's case, the use of force issue was essentially a moot issue. And I think the defense recognized that, and they smartly devoted most of their arguments and attacks towards a causation prong in this.
Okay, and they both landed, of course, in the hands of jurors. We await the verdict from the Chauvin trial jury. In the meantime, my thanks to Dan Herbert and James Montgomery for joining us.
Our pleasure. Thank you.
Thanks, Brandis. James, take care.
You too.